I would like to call to order the proposed Development and Planning Services Committee for July 8th, 2025. Having already had an invocation and pledge, roll call still showing full quorum. I'll ask for approval of the previous meeting's minutes for June 10th. Moved. Now then, approval of the agenda. I understand we have one new item added, I2A. Anything else, gentlemen?
That's all, Mr. Chairman.
All right. And we'll accept the agenda and move forward. Straight into the debate agenda and new business. Mr. Slaughter.
Thank you, sir. This is ordinance number 2506. This will amend Chapter 34 of our code for major site grading. If you remember about a month ago, you voted to amend some of the Chapter 90 when it came to buffers. This follows in line with that change. We did change the buffers in Chapter 90 down to a 25-foot buffer. Chapter 34 requires a 50-foot buffer if you're going to do major site grading, so we will reduce that down to 25 foot as well. However, there is now a requirement that it will be contained in the common area, so it's not part of lot, so it will be part of the common area, so it will be protected. We also, in Chapter 90, you allowed the use of a planted berm. This now is reflected in Chapter 34. Street trees were addressed in Chapter 90, so it is taken out of Chapter 34 here. Then one of the biggest things we did is Chapter 34 put limits on how steep a slope could be as part of a parcel. So this allows them 3 different ways of designing slopes to be included as part of a parcel for a home. There is a typo in what we have here. We will get this corrected before it comes back in front of you. We have our 4-to-1, our 3-to-1 are copies of the same thing. So there's a 200-foot, a linear foot requirement that should be a 150 on a 3-to-1. We'll get that addressed before it comes to you. But basically, this says if you come in and put some subsurface drainage in, you can go with a steeper slope. It also states that there's got to be clear direction in HOA documents that the HOA is responsible for maintaining slopes regardless of how the failure occurred. They have to maintain the slopes behind these homes that they're constructing. I believe that's everything. I'd be happy to answer questions. I know that's real quick and kind of convoluted to throw at you at one time.
So most of this is just truing up Chapter 34 with the Chapter 90 changes we've already made.
I would say half of it. The other half would be the slope, changing the requirements for slopes, giving the designers other ways of designing slopes behind houses in order to include it as part of the lot.
Have the builders weighed in on some of these?
We have met with the builders.
So this is actually a result of one of the items that came out of the County Manager Development Advisory Board. That is the new board that we have put in place at the request of the commission to work with the development community. And this is a lot of the items that they brought to the table. So it was really responding to their needs and requests and something that works for the county.
What is the teeth in this ordinance as opposed to maintaining? How can we enforce that?
The maintenance of the
slopes and the...
Well, it's all, once it's deeded over and sold, it's all private property.
Okay.
So it would be a civil matter between the 2 properties, but however, the code would be, I don't want to speak for our attorney, but I would say the code would give the plaintiff some teeth.
grounds.
Correct.
Gotcha.
The problem that we're running into now, as you're aware, is some of these buffers are on private property. When they sell the individual lots, the homeowner goes on there and wants a bigger backyard. So if the fence is, farther back, then they clear out all the rest of that buffer. This is going to prohibit that or help with that.
Yeah, that's my concern. It doesn't necessarily prohibit it. It just tells them they shouldn't do it. This is being an ordinance. This requires a debate agenda.
Move to debate.
Second.
All right. So moved. Next item, development services.
All right, the first item of consideration is the agency user agreement renewal with Georgia Crime Information Center. December 1st of 2015, the commission agreement with the Georgia Crime Information Center to obtain criminal history information for applicants applying for the alcohol beverage license. For this to be done biannually. Staff recommends approval of the updated agreement.
What's your pleasure?
Second.
Moved. Item 2, sir.
Second item we have is a memorandum of understanding with the Sheriff's Office for the fingerprinting. Same situation here. This is something that's biannually that the GCIC requires. And the Sheriff's Office is the one who does the fingerprinting for this jurisdiction. Staff recommends approval. of them.
Consent.
Second.
Is that done digitally now, or is that done,
I'm assuming that is. Last time I had.
Last time I had it was digital when I renewed it.
Right.
Out of curiosity.
item 3, sir?
Next item is resolution 25-21, adopting the fee schedule for alcohol beverage license. As preparation for this new software we've got coming on, Ms. Hall has done a pretty good, good thing going through all of the fee schedules, and we just want to clarify a few things and clean up the few we had. First one will be the clarifying the retail consumption dealer eating establishment less than 1,600 square feet. Calculated, how that's calculated. Trying to clarify that by the total enclosed area, not just the, say, the dining room area. There was a little understanding there, so we just that out. The second will be the change in temporary alcohol beverage permit administration fee to ensure that fees are covered in the staff time. This is another good area where Ms. Hall's gone through and sort of electronically made things a little bit better, so it's a little bit of a reduction in the fee schedule. Always look at it, you know, how we could maybe reduce some fees and stuff, so that's another good catch there. And the next one is remove other jurisdiction catering permits. These permits are temporary alcohol beverage issued for business who already holds a catering permit or alcohol license. So we're just removing that and make them all the same, whether they're within our jurisdiction or outside our jurisdiction. That brings those the same. They're again another savings. So staff's recommended forwarding this resolution to July 15, 2025 for debate.
The temporary permit,
Right.
moving it to 25, how much was it before?
Or anything outside of our jurisdiction, if you held a catering license, you know, you could sell alcohol, it was 50. Now we're just doing away with that and making it 50 for both. So it's bringing it more in line, because like I said, with all the electronics stuff we have now, we don't have that additional cost associated with it. So we're bringing it in line with what it's actually costing us to do permits.
Second.
So that is moved to debate. All right,
All right.
Adam.
Next one we have is ordinance 25-05, amending Chapter 7 taxes, Article 5, occupational tax and licensing, Section 149, tax due on payable, due and payable. Staff recommend amending Columbia County Ordinance 78-149 to require occupational tax paid at the time of application for the new businesses. If right now we're doing it, or you apply, once we approve your license, come back and pay that time, we're having to chase people down to get that payment now. So if we make it at the time of application, we're spending less time with staff going out. Right now, you know, Aaron's staff is trying to track these
Makes
people
sense.
down. Once it gets past January 31st, then code enforcement has to get involved, so cut back on staff time. Staff recommends ordinance
Sense to me.
July 15th.
Move to debate. It'd be
Second.
consent, this is a debate issue, right?
It is a debate issue, also an ordinance.
Second.
All right, move to debate. Planning services.
Good morning. I got a couple of easement encroachments for your consideration. The first one up is tax map 075, parcel 200. It's at 2418 Lawrence Street. It's for a pool deck encroachment within a 20-foot D&U with a storm line that's in the ground. Proposal is for the deck itself to be within the easement up to almost 5 feet. Staff's reviewed it and does not see any concerns with it, so they are recommending approval.
Move to consent.
So moved. Item 2.
Item 2 is also an easement encroachment for tax map 065, parcel 344. It is at 973 Mitchell Lane. It's for a pool, an existing shed, and a screen wall within a 10-foot drainage and utility easement. The pool itself would be 3 feet off the property line. While it is certainly congested and busy back there, staff has reviewed it. Concerns concerns and is recommending approval.
Consent.
Second.
So moved. And a resolution.
Yeah, so we have Resolution 2522, Planning Services Fee Schedule Revision. House Bill 1292, a year ago, provided some additional requirements that previously made it easier for folks to self-file paper documents at the clerk of court. Now that is no longer the case. There are certain, there's a list of approved filers that can file paper documents at the clerk of court, and regular citizens are not one of those. So in the case of these easement encroachments, when you execute those after the BOC meetings, we hand them back to the applicants, who are then required to go file those on record. They can no longer paper file, so they have to e-file. They would have to find somebody who is licensed or able to do that. So what we are proposing here is to just go ahead and increase the easement encroachment fee from $55 to $80 to provide for that $25 recording fee at the clerk of court. Then staff would then go ahead and record that, and then it'd be completely done, and then hand it back to the applicant. Staff's recommending.
Them having to do it themselves.
Correct, or having to go find somebody like a surveyor or an attorney or somebody who's qualified to, or go through the e-filer process, which if you do it one time, it really doesn't make sense for the average citizen to do that. So we think this is just a cost savings and time, inconvenience factor that that will help the residents of our county here. So we're recommending approval of the new fee structure from $55 to $80 for easement encroachments, and that's a recommendation to the debate agenda.
It costs us $25.
Yeah, to record anything, it's $25 for that. I think it's like 4 or 5 pages.
We're not charging for the
No, it's just
time or anything.
pass through on
Move to
the
debate.
recording fee.
Second.
That's to debate. Okay. We do have the one additional item, I-2A.
Yes, sir. This is Amendment 4 to our contract with Ceres Environmental Services for Emergency Watershed Protection Program Services. So, as you're aware, we've been under contract with Ceres for over 5 years now. We do have prices from Ceres to handle pretty much everything that happens during a hurricane or tornado. Recently, we were awarded a grant from NRCS EWPP up to $31.6 million to clean waterways that they deemed eligible. However, our prices are not done the same way they'd like us to bill. So we are paying in our contract by volume. They want it listed per linear foot. So we had Ceres go back and convert their prices from volume, a cubic yard, into a linear foot. So they really had to go back and guess how much volume was going to be in a linear foot. So you could have a really impacted stream that has a lot of volume per linear foot, or you could have a minor impacted stream which has very little volume per linear foot. So they really are having to put their pen and paper to work to come up with a linear foot price. We have reviewed this linear foot price. It is $128 per linear foot. That linear foot could be 50 foot wide, 25 foot each side of the stream bank. The wider the stream, the wider that linear foot is. So again, they're guessing
This is
on.
based on the width of the stream, not what's being removed from the stream.
That's correct. That's the problem.
I wouldn't think a business would do anything that would pay them less money.
Which is why we had to give them the opportunity to tell us the new price. We did not bid it the way EWPP wanted. So, Mr. Titus has reviewed it. He's reviewed it compared to some other locations. Based on our numbers of what we have approved linear foot wise and the price for linear foot wise, we are nowhere near the dollar amount that we've been approved for. We are well under it, probably 75% under. So the money is there to do this. We do think this is a good price, so just it amends that price. Also, I will tell you that our original prices for the contract are all broke down per action. So picking up one price, grinding one price, disposing one price. This is a all-in-one price. So pick up, grind, dispose in place. Hopefully we can dispose in place, but all that's included in that $128 per linear foot.
They dispose in place.
If you're in the woods along the stream, you're grinding the mulch. You leave the mulch along the bank to help with erosion instead of having to haul it off and like we do.
Come downstream.
Hopefully not. They can't place it in the water. Have to.
Well, get a good rainstorm and
They do have plans to haul off when needed, dispose of. We would also not remove tree stumps along banks. We'd leave the tree stumps in place to help erosion control. We want to lock in that dirt, so we don't want to start pulling stumps out of the edges of the banks. So this won't be quite as the same as when we did right away. Right away, we got everything and hauled it off and ground it, so we're in the woods on this long stream, so we'll have a different approach.
Move to consent.
Second.
So moved. I believe that handles our business for today. Any legal matters, sir? Seeing none, we'll move into staff reports. Planning Services.
Yes, attached for information only is the June 25 Planning Department workload. Happy to answer questions you have.
Questions?
Questions? Taken for information.
All
Next,
right.
sir.
Also for your information is the May 25 Plan Review Workload and Measurement Monthly Report. And answer any questions you might have about that.
Questions? None? Congratulations. Moving through to Development Services.
All right, the first one we have is Development Services, Division Monthly Report, and attached is a copy of that for your information. This is for FY '25, those are the final numbers of that year. So we're up about 8% residential and about 33% on the commercial permits. Other numbers, that's pretty much. If you have any questions, I'll be glad to.
Thoughts on this? Moving on, next report, sir.
Next report we have is a financial report, and a copy of that is attached for your information.
Thank you, sir. Next.
Final one we have is temporary events alcohol permits, and a copy of that is attached for your information.
No questions about the alcohol permits? All right. Thank you very much, sir. We'll take all those reports for information. Are there any commissioners' comments, any public comments, any public commissioner comments? All right. Seeing none, we have no executive session. We will adjourn until Tuesday, August 12th, and we will meet again. We are adjourned.